If the Attorney General were to reprimand rogue police for brutality, we'd have a situation that would involve the Department of Justice of the United States enforcing some of the specific criminal laws of the United States against those rogue police officers. And two come to mind immediately: Title 18 of the United States Code, sections 241 and 242, because they deal with criminal violations of civil rights being rights under the Constitution or perhaps rights granted by particular statutes. Those particular provisions deal with violations of civil rights under color of law. So they would clearly reach activities by rogue public officials in acting in some police capacity, because the police are always acting in some way under color of law. Those civil rights would include rights such as the First Amendment, the Second Amendment, the Fourth Amendment, the Fifth Amendment, which tend to be the categories of rights that rogue police officials infringe upon. Now, what's interesting about those two provisions is the seriousness of the penalties that are involved. Both of them state that a violation of civil rights where death results to the victim is punished by life imprisonment or the death penalty. So given that many of the episodes of police brutality that occur in this country in fact do involve the death of the victim whose civil rights has been violated by those rogue officers, you're talking about extremely serious penalties that could be applied in those situations. And if they were, in fact, even if those penalties were simply threatened, if the Department of Justice was simply to make a statement that it was going to go forward and enforce those civil rights statutes very, very strictly against rogue police officials, you would have a tremendous amount of individual deterrence against those rogue officers. They would have to think 2 and 3 and more times as to whether they were going to engage in that kind of behavior, recognizing that if they did, they might be facing a criminal trial where life imprisonment or the death penalty would be imposed upon them. As well as the individuals, you would have deterrence that would reach into the institutional structures, because much of what goes on with rogue political officials of any kind, or rogue police in particular, is determined within some institutional context. These people don't necessarily go off on their own and engage this way. In some sense, they have been trained to do it. In some sense, they have been told that if they do it, they can somehow get away with it. So you have institutional problems. And Section 241 of Title 18 refers directly to conspiracies to violate civil rights. So that would tend to bring in the situation where within some police department, you had policies, practices, training, or whatever that was leading the individuals to engage in violations of civil rights on the streets, and that would then cause those people who were in policy-making decisions to be subject to criminal prosecution, which of course would deter that kind of action institutionally.